Court will call case number 628-903, State of Texas versus Casey Mooring.
Here we are.
State ready?
State's ready.
Defense?
Yes, we're ready, Your Honor.
All right, Mr. Mooring, please raise your right hand. You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. You may put your hand down. Mr. Mooring, before we proceed, I need to discuss on the record some constitutional rights and protections that are critical that you know and understand. Let's start off with the very basic right to remain silent. That means you do not have to say anything. You don't have to answer questions. You don't have to submit paperwork that has your signature, especially any papers that would admit or confess to wrongdoing. Do you understand you have the right to remain silent?
Yes, sir.
You have the right to a jury trial. That's a proceeding wherein you and your attorney and the state would select from a random pool of people, 6 people, to hear the evidence and decide whether you're guilty or not. You understand you have the right to a jury trial.
Yes, Your Honor.
All right. There's also the right to confront witnesses. That means if you go to trial, you'd have the right to cross-examine, question, or challenge any witness that would testify. You understand you have the right to confront witnesses.
Yes, Your Honor.
All right. You also have the right to what's called the right of appeal. That's the right where you or your attorney or the two of you, in a proper manner, following timelines and the right documents, you could demand that a higher court review this case, the evidence, and the official record that is being prepared by Ms. Rivera, our court reporter. That review would be for whatever challenge you wanted to make. That's the right of appeal. Do you understand you have the right of appeal?
Yes, Your Honor.
You also have the right to have this hearing in a public courtroom. That, in fact, is a right that both you and the defense have, or rather the state. Sorry about that. All right. Now, that right to have the hearing in the public courtroom, we've suspended that right because of the COVID pandemic. But nonetheless, it is a right that you and the state can demand a public hearing. You understand that there is such a right.
Yes, Your Honor.
We are in fact doing this by video conference, and it is being put on YouTube, which makes it somewhat public, but not in the public courtroom. Now, those rights that I have just mentioned to you, if you persist in entering a plea, you give up all of those rights. Do you understand that?
Yes, Your Honor.
And are you willingly, voluntarily giving up those rights?
Yes, Your Honor.
Okay, now I'm going to show you a series of documents. Those documents, all of them with very little, one exception and a minor exception, the documents will have identifying information, which you see here in this particular document at the top. The identifying information is the cause number 628903, the state of Texas versus Casey Mooring, in County Court of Law number 5, Bexar County, Texas. Then you have, in this particular case, the title of the document. It's State's Consent to Video Conference. The titles are in all capitals, bold print. This particular one, as I mentioned to you earlier, you and the state have the right to a public hearing in the public courtroom. In this case, Andrew Harris Ailman, Assistant District Attorney, has consented to do this by video conference. Did you see that document?
Yes.
Yes, sir.
All right. Now, the second document, again, identifying information as in the other. The title of this one is Discovery Acknowledgement. This particular document refers to a law that is identified as Article 39.14 of the Code of Criminal Procedure. This particular document refers to a law that requires the prosecution, the state of Texas, to provide access to you to all receipts, documents, information, evidence, even, for example, videos or whatever. Make it available to you so that you and your attorney can make an intelligent and informed decision. This is signed by the state's attorney and by your attorney, indicating and agreeing that the law has been followed in that case. Did you see that?
Yes, sir.
Now, all these documents I'm showing you, did you review them carefully with Mr. Hicks?
Yes, sir.
All right. This document now before you, again, has identifying information. This in particular is your written consent to video conference. Did you see it, understand it, and sign it?
Yes, Your Honor.
All right. The next document, again, identifying information at the top. This one is titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. It starts off with three sentences, individual sentences separated. The first one says, you don't need me. You're waiving the right to have me read to you word for word the official document that accuses you of criminal mischief from $100 to $750. In fact, the second sentence says just that you know exactly what you're charged with. And then the third one says, I hereby enter a plea of nolo contendere, that's no contest, to the charge of criminal mischief 100 to 750. Now, the rest of this document is divided into 15 separate sections or divisions. Each one is separately numbered from 1 to 15. Number 1 talks about the Class B misdemeanor range of punishment, because that's what this is, a Class B. The punishment can be anywhere, a fine from anywhere from $0 to $2,000 and jail anywhere from 0 days to 180 days. Is that understood? Is that clear to you?
Yes, sir.
All right, did you read number 2?
Yes, Your Honor.
What does it say?
I understand I have the right to a jury trial, a right to cross-examination of witnesses, and a right to remain silent. I freely and voluntarily give up those rights.
All right, and you understand that clearly, right?
Yes, sir.
All right. Number 3, have you ever had any kind of mental health problems?
No, sir.
Have you ever been given or taken mental health medications?
No, sir.
All right, and you read the rest of these paragraphs?
Yes, Your Honor.
Number 8, where were you born, sir?
San Antonio, Texas.
That makes you a U.S. citizen, and that will be so noted in the paperwork. Have you ever been in any way involved with the sex offender program?
No, sir.
All right. Number 15, all of these rights and constitutional protections you're giving up. Number 15 says that you're giving up the right to a risk and needs assessment. Is that correct? You're giving up that right?
Yes, Your Honor.
All right, and I see your signature there. Very good. I will be approving all these. Now, this particular document, again, identifying information. The title is Trial Court's Certification of Defendant's Right of Appeal. That is my certification to you. And for the record, there's a bunch of little boxes, little squares there. Each one has an individual description of the right of appeal. The 5th box that'll be marked says this is a plea bargain case and the defendant has no right of appeal. Did you see and understand that declaration?
Yes, Your Honor.
And I see you signed that document too. So has your attorney. Now we have the next document, again, identifying information. We have an application for deferred adjudication. Deferred adjudication is particularly advantageous to you because, first of all, even though you're going to enter a plea of no contest, which in this court is taken as a guilty plea, that is sufficient for me to convict you just on your nolo contendere plea, but I will not. I will honor the agreement that you've made, and if you listen very, very carefully, if you live up to 100% of the conditions of supervision, the deferred adjudication, then the case will be dismissed, and under Texas law, you are not convicted. You do not have a conviction for this charge. If you fail or refuse to live up to the conditions, then the state may ask me to give you official notice to bring you in for a hearing. And that in the result of that hearing is that I can enter a finding of guilt, and you will have a conviction that follows you the rest of your life. Exception being if you were such great friends with the governor of Texas that he'd pardon you. Do you understand that?
Yes, sir.
Furthermore, if you were to be convicted as a result of a hearing, then you'd be looking at the full range of punishment, a fine from $0 to $2,000 and jail from 0 days to 180 days. Is that clear to you, sir?
Yes, Your Honor.
All right, now, question. Do you understand that, do you understand clearly what you told me by signing that application? What's in there, what you're averring to?
Yes, Your Honor.
All right. Now, this personal data sheet, it says you work for Delta Steel. You are looking at $24 an hour is your full-time pay?
Yes, Your Honor.
Okay. You've got 3 references. They're up to date. That's accurate information.
Yes,
You
Your
have
Honor.
0 dependents? You have no dependents?
No dependents.
All right.
Judge, one question, please. Under
Yes,
place
sir.
of birth, should he put San Antonio or just United States? He was born in
Well,
San Antonio.
The United States is sufficient, because the real question is he a U.S. citizen?
Thank you.
All right. Now, the scroll, please. The next document now, this is all informational here, but the next primary document is the plea agreement.
What happened? They shifted it?
They're
No,
done.
it's, we're changing documents, and it's at a point where Ms. Garcia has to kind of close down and reopen with the last document. Here it comes. There it is. All right. This one has titled plea agreement. It has your name and the case number. It doesn't have the court number. The first 2 boxes will be checked off for a matter of final record. The first one saying that you have been very much aware of the right to remain silent, etc. The second one says that you are a U.S. citizen. Then you have another section, there's defendant's acknowledgements. It says there that you've made 5 check marks on there saying that the declarations and information next to those boxes are true and correct. Is that right?
Yes, Your Honor.
All right, then the next section we're interested in is non-DWI allegations. This one says other criminal mischief 100 to less than $750. So then officially your plea to that charge is what?
No contest.
All right. Now, I remind you, a no contest plea is sufficient for me to convict you. Do you understand that?
Yes, Your Honor.
All right. Now, I do not find you guilty. In accordance with the agreement that you've made with the state, you are granted 12 months deferred adjudication. The fine that is open at this time, Mr. Edelman?
No, Your Honor, there is no fine.
There is no fine. Okay, restitution to Jacqueline Vargas in the amount of $1,031.98.
And Your Honor, I apologize for interrupting, but there is one additional condition which I failed to put on the plea agreement form, but of which defense counsel and Mr. Mooring are aware, and that is an order of no contact with Jacqueline Vargas.
All right, that will be included in there. Mia, if you will make sure that that gets into that document, please. I am not pleased with no fine, but let me go ahead and scroll a little bit, Patty. The supervisory fee, I will set at $60 a month.
What you need?
The paper.
Let's talk about that fine, gentlemen. You all agreed to no fine. With the money that you make, Mr. Mooring, I am not satisfied that you should walk away with no fine at all. And I am going to assess a fine, but I will tell you this. Since I am assessing a fine, that makes this my sentencing greater or heavier than what you've agreed to. And under the law, that means that you could reject my rejection, you might say, and start all over again if you choose to. That'll still be in this court, but I'm going to fine you $750. If you don't accept that, say so. You can start over again. We'll give you 30 days to come back and consider it. But you make a lot of money, and when you damage people's places, even if you make restitution, that's paying back what you did. But that's the state. Then this court is letting you walk away without being fined, and I don't agree with that. You've got a hell of a deal with it just by getting it deferred, where you're not going to be convicted of this. So my fine is $750. You want to talk to your attorney, you might consider starting all over. That is your right.
Do you agree with the 750 fine? Or you wanna,
Yeah, we can do that.
huh?
Yeah, we can do that.
You will?
Yeah.
Okay. We agree to that, Your Honor.
All right.
Your Honor.
The hope is that Mr. Mooring, having gone through this process and having to have attorneys help, I want to make damn clear to you that this is kind of behavior that should not be happening. Now, I have another question. Ms. Garcia, perhaps you can answer it. Mr. Hicks was appointed to represent him.
Yes, sir.
That means that the state paid for his attorney.
Yes, Your Honor,
Mr.
but that appointment was since, I think, 2017 or 2018.
Okay, so the job you have now has been after you got an appointed attorney? Mr.
Me?
Mooring?
What was that now?
Okay, you have a court-appointed attorney.
Yes, sir.
In my opinion, that should not have happened based on your income, but Ms. Garcia points out that the court-appointed attorney, you got that quite a while back, and at that time, were you employed with this same job? And probably, I hope not.
Your
I
Honor,
was employed, but I was not at the current pay grade.
All right,
it says he was appointed December 7th, 2019.
all right, I want to take this up with our administration, Patricia. What were you earning back then in 19, Mr. Mooring?
I don't recall, sir.
It might be in your interest that you don't, because it appears that you should not have qualified for that.
The system, the jail did the interview. It shows the system appointed Mr. Hicks, and then I subsequently appointed him to his second case.
All right. Okay.
And
so
Your Honor, you forgot to mention the
oh,
TIC.
Mr. Mooring, within 7 days, the court orders you to appear in the courtroom, actually in the offices of County Court of Law number 5, and submit to having your thumbprint placed on the court documents where it's required. In addition, case number 640553 is taken in consideration in this plea, meaning that that case 640553 is dismissed. All righty. Questions, Mr. Moore?
Is it possible if I can do the thumbprint today?
Do we have the papers in the courtroom, Patty, at the offices?
I'm not sure, Judge. You would have to ask Miss Salinas. Mia, I don't know which courtroom they're at, Judge, but they're not in County Court 5.
Court number 1.
On the first floor, sir.
Mia,
I would suggest that you wait till Monday to be sure that we have the paperwork there and not go over there and waste your time being told, well, no, we don't have them yet. In fact, you can call 335-2549. That's the courtroom, the court office number, and verify that the papers are there so you can go over there and put your thumbprint on it.
What was that number one more time, sir?
210-335-2549.
This is Mia. I'll head over there in just a few minutes. Sorry, on the phone. For the thumbprint.
And Your Honor,
Yes, sir.
you have signed both the plea paperwork and the plea agreement, so they are now in the email inbox for the County Court 5 clerk. So they should be available to print and for Mr. Mooring to apply his thumbprint.
And that would be actually as of this moment. Is that correct?
I believe so, sir.
All right, Mr. Moore, check this afternoon at your convenience, find out.
Your Honor,
Yes, ma'am.
Miss Salinas said that she was going to take the paperwork to them, to County Court 1 to get it signed or thumbprint.
Okay. Okay, is that understood, Mr. Hicks? Mr. Mooring?
Yes, Your Honor.
Yes, except for the order of no contact, Mr. Elderman. How can we get that signed?
That'll be part of the judgment. You're ordered not to have contact with the individual we mentioned here in the record. All
Mr.
right.
Hicks, it will be included in the written judgment that is produced by the court.
What do you say?
It's included in the written judgment that is produced by the court.
Thank you.
All right. Now, Mr. Mooring, any other question?
Where do I go to pay the 750?
Maricelo, would you be able to answer that